This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute.
Welcome to the December episode of Eye on Bankruptcy, a monthly discussion and analysis of recent cases and developments in the bankruptcy world produced by the American Bankruptcy Institute. This program will give you 1 hour of CLE credit in states where it is pre-approved. My name is Charles Tabb. I'm the Mildred Van Voorhis Jones Chair in Law Emeritus at the University of Illinois College of Law. Also, I'm of counsel with the law firm of FOLEY and LARDNER LLP in Chicago, and I'm your host for Eye on Bankruptcy. We're very fortunate today to welcome two distinguished guests, Judge Thomas Catliota from the United States Bankruptcy Court for the District of Maryland, and Katie Catanese from FOLEY and LARDNER in New York City. The Honorable Thomas J. Catliota was appointed a United States Bankruptcy Judge for the District of Maryland in 2006 and currently serves as the Chief Judge. Prior to that, Judge Catliota was a partner in the law firm of Pillsbury, Winthrop, Shaw, Pittman, and his Washington, D.C. predecessor, Shaw, Pittman. There, he chaired the bankruptcy and insolvency practice for 7 years. He addressed all aspects of insolvency law, including the representation of debtors, creditors, or committees in bankruptcy courts across the country, and specialized also in commercial litigation. Judge Catliota formerly served as the chair and the Fourth Circuit representative of the Bankruptcy Judges Advisory Group, which advises the director of the Administrative Office of the United States Courts on matters pertaining to the operation of the bankruptcy court system. He is a regular speaker at bankruptcy seminars and conferences. Judge Catliota is a graduate of Marquette University, where he earned his B.S. degree, and the Columbus School of Law of the Catholic University of America, where he received the Faculty Award. In 1985, he earned a Master of Laws in Taxation from Georgetown University Law Center. Judge Catliota, welcome again to Eye on Bankruptcy. Katie Catanese is a partner in bankruptcy and restructuring and attorney with FOLEY and LARDNER LLP in New York City. She focuses her practice on representation of creditors' committees, post-confirmation trusts and trustees, and has extensive experience in international and Chapter 15 cases, often involving cross-border fraud, has represented investors and managers in hedge funds both onshore and offshore. Katie earned her JD with honors and her BA in psychology with high honors from Michigan State University. During law school, she was a clerk for the Honorable David L. Jordan. Prior to joining FOLEY, Katie was an associate at Allard & Fish, P.C., where she represented a Chapter 7 trustee, corporate debtors, secured and unsecured creditors, and trustees in all aspects of bankruptcy litigation. Katie was named one of the American Bankruptcy Institute's 40 Under 40 Emerging Leaders in Insolvency Practice in 2018. This year, she chaired ABI's Mid-Level Professional Conference. She has published extensively on bankruptcy topics and has spoken at many bankruptcy and insolvency professional conferences. Katie, welcome.
Thank you.
Today we will discuss 6 topics. First, we will explore what it means for a claim to be impaired in Chapter 11. Impairment is significant, of course, because a claim that is not impaired does not get to vote, but indeed is conclusively deemed to accept the plan. In the Fifth Circuit case of In Re Ultra Petroleum Corp., the debtor's plan provided that all creditors were not impaired and thus could not vote on the plan. However, the plan did not propose to pay make-whole premiums to bondholders. Further, did not propose to pay the revolver lenders post-petition interest at the contractual default rate, but only at the lower federal judgment rate. Thus, without question, certain creditors were getting less under the plan than they would have been entitled to under non-bankruptcy law, and those creditors thus argued that they were impaired and were entitled to vote and would have voted no on the plan. Fifth Circuit, however, rejected the creditor's premise that impairment is judged with reference to their full non-bankruptcy entitlements. Instead, according to the Fifth Circuit, if other provisions in the Bankruptcy Code disallow or override part of the creditor's non-bankruptcy rights, that does not count as impairment. That is, the impairment has to be done by the plan itself, and the plan operates with reference to a claim after other provisions of the Bankruptcy Code have done their dirty work. So, for example, if 502b2 disallows a make-whole premium, then proposing a plan that does not include payment of the make-whole does not count as impairment. Court of Appeals remanded to the bankruptcy judge to decide whether make-wholes and a contractual default interest rate were disallowed by other provisions in the code. The bankruptcy judge had not previously ruled on the issue, but instead had taken the view that any departure from state law entitlements counted as impairment. Our second topic addresses a jurisprudential issue that is important in bankruptcy cases, but which resonates far beyond the parochial confines of the bankruptcy law itself. Question goes to whether the demands of equity can ever override what appears to be a plain statutory provision, and if so, on what kind of showing. This problem goes to the very heart of separation of powers between the judiciary and Congress. Congress wrote the statutory rules we find in the bankruptcy code. Judges see and want to be able to make adjustments for equitable considerations evident in the cases before them. Supreme Court has spoken to this issue twice in the last dozen years and has taken conflicting tacks. In Marama back in 2007, the court took a capacious view of the power of a judge to invoke equity to rewrite a statute that strictly applied arguably led to an inequitable result. However, in 2014 in Law v. Siegel, the court took a dramatically different approach and held that equity cannot trump a clear statutory demand. In the law, facts and law were very compelling. The bad guy against whom the court wanted to rewrite the code was a very bad guy indeed. In the case of N. Ray Ballou, the Eighth Circuit concluded that the Supreme Court meant what it said in Law v. Siegel, and accordingly the court had no power to deny an exemption in a big pot of cash that the crooked debtor had claimed as exempt, but which he'd only claimed as exempt after he tried to hide the asset in the first place but had gotten caught. Our third topic is one of acute interest to thousands and thousands of individual debtors and highlights one of our biggest social problems. One of the most common causes of bankruptcy for individuals is medical debt is either uninsured or underinsured. For many debtors, they owe tens or even hundreds of thousands of dollars in medical bills. The issue confronting bankruptcy judge Mary Gorman from the Central District of Illinois in the case of N. Ray Zagonina was whether medical debt had to be counted as consumer debt for purposes of the abuse test of 707B. It matters because individual debtors are only subject to the abuse test in the first place if they have primarily consumer debts. For a debtor such as Erin Marie Zagonina, the answer to the question was outcome determinative as to whether she would be potentially subject to having her Chapter 7 case dismissed as an abuse based on a failure to pass the means test. And if her Chapter 7 case were dismissed for abuse, her only realistic bankruptcy option would be Chapter 13. And in Chapter 13, as an above-median debtor, she would have had to pay every penny of her disposable income to creditors for 5 years. In short, a lot was riding on the answer. Interestingly, there are surprisingly few decisions that squarely address the question. Judge Gorman held the debtor's medical bills were consumer debts. Therefore, she was subject to the 707B abuse test and had to either fill out the forms 122A1 and 2 and either convert her case or convert to Chapter 13. Our fourth topic takes us back to the world of fraudulent transfers, which it seems we visit every month on this program. The question before the First Circuit in the case of N. Ray Telex Free LLC is an important one, asking whether the bankruptcy trustee alone has the power to pursue clawbacks against net winners in Ponzi schemes, or whether net losers also enjoy the right to sue net winners directly. What had happened in that case was that a number of the creditors who had been net losers in the Ponzi scheme tried to get the jump on the bankruptcy trustee and brought independent lawsuits against the net winners based on an unjust enrichment theory. The trustee then brought an adversary proceeding to enjoin the unjust enrichment suits. First Circuit held for the trustee and concluded that the bankruptcy trustee does have the exclusive power to pursue clawback litigation against net winners. Such prospective recoveries are an asset of the bankruptcy estate. The court noted it does not matter how the fraudulent scheme is structured if in substance it is a Ponzi scheme. For our next topic, we'll travel back to my home circuit, the 7th, where it seems the general topics of cars in Chapter 13 are well nigh ubiquitous. We have talked before about the problem where the creditor has to give the debtor her car back upon filing, no questions asked. And if I just interject, the Supreme Court just granted cert on that. Earlier this year, the 7th Circuit scuttled an effort by debtors to keep the car as estate property as opposed to revesting as property of the debtor after confirmation. This distinction is important because the automatic stay remains in effect if the car is estate property, and then the City of Chicago could not collect parking tickets without getting the stay modified. In the case of N. Ray Steens, the court had to decide a related question whether parking tickets and fines incurred during the Chapter 13 case are an administrative expense priority. Court of Appeals, drawing on the iconic Supreme Court case of Redding Company versus Brown, concluded those fines and tickets were entitled to administrative priority, which means that a debtor must promptly pay such tickets and fine. If not, her Chapter 13 case might be dismissed. For our final topic, we revisit an issue we've previously discussed on the show. We do it because we now have the first Court of Appeals ruling on that issue. In Re Palladino, the First Circuit held that it is a constructively fraudulent transfer for insolvent parents to pay college tuition for an adult child. Given their insolvency, the question turns on whether reasonably equivalent value is given in exchange. First Circuit had a little trouble concluding that the debtors did not receive any value in exchange. Now note, in that case, the college was definitely the initial transferee and thus faced strict liability and could not argue it was protected under 550B as a good faith transferee for value without knowledge of the voidability of the transfer. Given the increasing spate of this type of fraudulent transfer litigation, colleges are starting to wise up and are structuring tuition payments so the child is the initial transferee and then the college is the secondary transferee and thus perhaps able to get protection under 550B. Okay, Judge Catliota, let's dive into our first issue and first case, which is how we determine the concept of impairment in Chapter 11 plans. So our audience will have a little context. Can you lay out some of the facts in ultra petroleum? It's a weird case on the facts.
It is, and the Fifth Circuit said the facts were exceedingly anomalous, and were
not just anomalous,
not
but
just
exceedingly anomalous,
and that the facts were as rare as the proverbial rich man who was able to enter the kingdom of heaven.
There you go.
So it's quite
That's pretty rare.
That's pretty rare. So the debtor was and its subsidiaries are engaged in oil and gas exploration, and the fluctuations in the price of crude oil was what caused the filing. Pre-petition, crude went from $100 a barrel to $30 a barrel. Rendered the
That's bad.
That's bad. Rendered the debtor insolvent. Post-petition, crude went back up to $80. So that the debtor went from being insolvent to solvent. And that was the rarity that the Fifth Circuit was highlighting.
How often does that ever happen?
How often does that
Never.
Never. So the debtor was...
That's the rich man, you know.
Right. Exactly right.
Yeah.
So the debtor proposed a plan which all creditors were going to be paid in full and there was going to be returned equity. And the two creditors that you mentioned were in the same class, Class 4. One creditor, group of creditors, had make-whole provisions on their unsecured notes, and one creditor in the same class, and actually all the creditors in that class had the rights to default interest. And those creditors said that post-petition, the default interest was triggered, and they should get their default interest, and the make-whole provision was triggered, and it should get their make-whole provision. So the debtor proposed a plan that said these Class 4 creditors are unimpaired, but they were only going to get their principal, their pre-petition interest, and as you mentioned, interest at the legal rate post-petition. And
So no make whole.
no make-whole,
No
no
default
default
rate.
interest.
Which, by the way, is a huge issue. I mean, we represent a lot of indentured trustees and a lot of these bondholders, and we're not talking about a $1,000 issue here. We're talking about hundreds of thousands and, in some cases, millions of dollars that are at stake here.
In this case, it's $400 million.
That's right.
So
Big numbers.
That's a lot of money.
That's a lot of money. So the plan provided that they would be unimpaired, and the debtor made it clear they were unimpaired under Section 1124(1). And so as they approach...
And why is that important?
Well, there's two impairment provisions. 1124(1), which says that it alters you're unimpaired unless your legal, equitable, contractual rights are not altered.
Okay.
And there's also 1124(2), which says reinstate the maturity, cure the default.
That's the deacceleration.
That's the and that wasn't applicable.
That was not.
The debtor said clearly it was 1124(1).
So if you're unimpaired under 1124(1), what happens?
Well, that's exactly what the case was about. So what happened here was that the debtors, they went to confirmation, and the Class 4 creditors objected and said, we are impaired. So they reached the stipulation, and the stipulation was, we'll put the $400 million in escrow, we'll let the bankruptcy judge confirm the plan, and the bankruptcy judge will determine then what the Class 4 creditors get.
Gotcha.
Now the important point, one of the important points, is that the plan said that the bankruptcy judge is to determine what the Class 4 creditors get being unimpaired under Section 1124(1). So that was the bankruptcy judge's task. So the bankruptcy judge did analysis, and said the proper frame of reference is the plan and then Section 502B1, because the objection to the claim by the debtor made the assessment that the make-whole provision and the default interest were enforceable under state law.
Right.
So therefore, there was no objection under 502B1, and therefore, to meet the debtor's declaration that they were unimpaired under 1124.1, they had to get paid the full amount.
So just so I understand, the bankruptcy judge then is saying what our referent is for unimpaired is what would the creditors have been able to recover under state law outside of bankruptcy. And since they're getting $400 million less, they're not getting what they would have gotten outside of bankruptcy. Ergo, they're impaired. Ergo, they get to vote and all that stuff.
Exactly. The bankruptcy court started with the point that impairment is determined by the plan. Right. And in this case, the plan said they're unimpaired under Section 1124.1. Right. And to be unimpaired under 1124.1, you have to get what you would get outside of bankruptcy.
Right. Okay, so and just to throw in a little history, I mean, this the whole impairment thing in 1124 was derived from provisions in Chapter 10, which had a more a different standard. There was a requirement of material and adversely affected, and in the code they jettisoned that and basically said any alteration. But the interesting point that Judge Isker and then the Fifth Circuit really seemed to disagree on, it's really the critical point is, understand 1124.1 says you get whatever your rights are. But the question is, rights is determined by what? Is it rights after the bankruptcy code, other provisions have whacked you $400 million, or is it your rights outside of bankruptcy? And Judge Isker said it's your rights outside of bankruptcy. Okay, so the Fifth Circuit, though, takes what view?
So the Fifth Circuit took the different view. The Fifth Circuit said, look, if 1124.1 says you cannot alter the legal, equitable, contractual rights of the claim holder, to which the claim holder is entitled, legal rights is a broader concept than the legal rights they have under state law. Legal rights could mean the rights they have under bankruptcy code. So the Fifth Circuit took the view that in considering whether a creditor is impaired under 1124.1, you have to consider whether that the legal rights to which that creditor is entitled have been altered. If the legal rights have been altered by reference to the bankruptcy code, the statutory impairment, if you will,
Gotcha.
If that's how it's impaired, and you give the creditor what it is entitled to under the statute, they're not impaired. The creditor's not impaired because you have given the creditor that to which it is entitled to under the bankruptcy code.
How did they come up with that view? I mean, how did the Fifth Circuit arrive at that view?
It relied pretty heavily on the Third Circuit decision in PPI Industries, which was a case where the debtor had rejected a landlord's lease, and a landlord ended up with a very large lease claim. Outside of bankruptcy, that lease rejection claim would be very, very large, but inside of bankruptcy, of course, that lease rejection claim was capped by Section 502B6.
Right.
And so the Fifth Circuit said, the Third Circuit said, well, if you pay that landlord what it is entitled to receive under Section 502B6, it is the statute that's impairing the landlord's rights. It's not the plan. You are giving the landlord everything to which it is entitled. Therefore, the landlord is not impaired.
Gotcha.
Which is a very interesting and narrow view of impairment, I think. I think
Why, Kate?
Well, when you're sitting in the creditor's shoes and you're like, I'm in class 4 and I'm not going to get the option to vote here, that's problematic. And I
really
think,
wanted that $400 million.
Yeah, well, and I think when we were discussing this leading up to today's program, I think the big problem is you said this class of creditors is not impaired, but wait a second, they're fighting this all the way up to the Fifth Circuit. Sounds like impairment to me. They're definitely affected by what's going on. And to say that they don't have the right to vote, seems a little off to me.
Yeah, I mean, it's interesting because as Judge said, the Fifth Circuit, as the third head, basically focused on in 1124. It says the plan leaves unaltered, and they said, well, the plan's not doing anything here. The work's being done by 502B2 if you zap make holes or 726A5 on the. But that's only if you say that's what the rights referent is. Like if the referent is outside of bankruptcy, Judge Isker's thought, which is plausible. I mean, as you're saying, and if you sort of step back, I mean, we talked about this, the whole scheme in Chapter 11 is basically predicated on consensual bargaining among affected parties, and the thinking of impairment was, if you're getting what you would get outside of bankruptcy, you shouldn't get to participate in those discussions because you have no complaint. $400 million sounds like a serious complaint to me, and so one wonders whether. Well, Judge, let me ask you this though. So the court came out that way. I mean, here we have a $400 million hit, but would it matter in the final analysis? And here's what I'm wondering. Even if they were entitled to vote, he said, okay, you're impaired. You get to vote. And if you vote no and you have a big claim, you can control the class, you're going to have to go to cram down. So you go to cram down. Would the plan still be confirmable?
It probably would, but let me just step back for 1 second, because the what the Fifth Circuit said was, okay, the judge has determined that the claim is allowable under Section 502b1. So it's that we know what they're entitled to get under state law.
Right.
But because of the statutory impairment issue, the judge has to now look at what they're entitled to get under Section 502b2. Is the make whole provision limited by the bankruptcy code as unmatured interest, and the same with default interest? So it's going to go back, and I agree with you, Katie, that it's going to go back, and there's going to be litigation for years, perhaps back to the Fifth Circuit, and that sure doesn't sound like being unimpaired.
Yeah.
But you're right, Professor. I think had they been, of course, we know that being unimpaired has a couple of different effects. One is the economic effect. What do you get? The second is sort of the strategic effect of how do you get a plan confirmed.
Right.
If this had been the only impaired class, and it was impaired, and it voted against it, I don't know how you could get the plan confirmed under Section 1129A10, because you have an impaired class, it hasn't accepted the plan.
You have no hope.
But if you did have another impaired class,
They voted yes. Yeah.
then you get to the cram down of Section 1129B2,
Right.
and for the unsecured creditors, because equity is getting something, then it's not an absolute priority issue in the sense of they get whatever they get. You have to pay them their allowed claim, and to pay that Class 4 claim, the allowed claim, puts us right back in determining what that allowed claim should be.
And then you would.
Yeah.
All right. Well, thank you very much, Judge and Katie. So let's look at the Ballou case out of the Eighth Circuit, the one where you have the battle between equity and the statute. So, Katie, our debtor who's captioned, I love this, Johnny M. Ballou, also known as John Ballou, formerly doing business as Ballou and Bell Attorneys at Law. He's a shifty guy. What bad things did Johnny, also known as John, do?
I have to tell you, I love this case because it takes me back to the days when I used to represent Chapter 7 trustees, and
You
hiding
knew a lot of
assets and all that.
Johnnies.
Yeah, unfortunately, everybody was a Johnny Ballou when I was representing a Chapter 7 trustee. But I think what's important here is this particular bad guy, we'll call him a bad guy, was
That's a fair claim.
well, he was hiding $30,000 in cash. And I think what's interesting about this guy is he was hiding $30,000 in cash in a safe in his house. And I say he's hiding it because I don't know very many people that have $30,000 in cash in their house anyways.
I don't.
And I think that, as a person without $30,000 in cash in my house, if I had $30,000, I would remember it and I would list it on my bankruptcy schedules. This guy apparently forgot to list it on his bankruptcy schedules, or he was hiding it.
He's a forgetful guy.
I don't know. It's hard to know which one. And so then, of course, when the trustee found out about it, what does he do? As all debtors do, he tried to exempt it on his bankruptcy schedules, which means he gets to keep the $30,000 if that exemption holds.
So when a debtor claims an exemption, either originally or on amendment, what are the bankruptcy code rules on the allowance of that exemption? What then happens?
Generally speaking, the case law suggests, Law versus Siegel says that they get the absolute right to amend their bankruptcy schedules at will.
So they get their amendment unless the trustee objects, but the trustee did it. So, this goes back to Taylor versus Freeland and Crimes, where they claimed like $100,000 in the airline settlement as like exempt, and the trustee said, fine. And the Supreme Court said, yeah, you get it. But here the trustee objected. But the trustee's ground for objecting was Johnny's a crook.
Yeah.
Right?
Bad faith.
Bad faith, yeah. And the court ultimately says that's not good enough. So what would have been okay? What would be an acceptable basis for objecting then?
Well, look, 522 of the Bankruptcy Code, which deals with exemptions, is a very lengthy section. I think, for example, if the trustee would have challenged, for example, his wild card exemption under D5 and said, you know what, look, you claimed 8,000, it's only 7,500, that's all you get. That statutorily you're allowed. So the specific
So what the statutory,
grounds,
but if there were something either under the state or federal exemption, whatever he's claiming, that says you can claim 30,000 and you're safe, you can't say you're not entitled to the 30. In other words, if Johnny straight up at the start of the case had disclosed the 30,000 and is safe on his schedules, had claimed as an exemption, the trustee would have had no basis to object. So the trustee's only basis to object was he tried to hide it and then only amended his schedules. The trustee says you're in bad faith.
that's right.
Okay.
That's right.
So now, is Johnny, also known as John, getting away scot-free entirely in
I
this
mean,
case?
not exactly. But
Okay.
so what ended up happening in this case is, although the trustee lost on the objection to exemption, he filed a 727 complaint against Johnny. And he was arguing specifically that, and I don't know exactly what the facts of the 727 were, but it sounds like this guy falsified some records, concealed some property, and they got him for a false oath.
They got him for about
So-
half of the 727A. So he's not going to get a discharge.
Right.
So he's not going to get discharged. But the Eighth Circuit then, just make sure our audience understands, trustee objects as bad faith. He only amended his exemptions after I caught him.
Mm-hmm.
That's bad faith. They said, based on Law v. Siegel, what?
They basically said you have the right to freely amend. It doesn't matter if it's bad faith. It doesn't matter if you're hiding assets. It doesn't matter. You have the
Exactly.
right to freely amend. And that's a huge problem. I think, Judge, you brought this up, and this was a really good point going back to my Chapter 7 days. Trustees get paid almost nothing.
Yep.
So this trustee is essentially litigating an adversary complaint for dischargeability under 727, which is an expensive thing, especially when you have a lying debtor. And he's not going to get paid a dime unless there's other assets that we don't know about in this estate.
Yes.
And the debtor gets to keep 30 grand.
And not going to get paid for chasing the debtor and pursuing the fraud and all the things that we have to have trustees do.
That's right.
For the system to work. Otherwise, debtors get off scot-free.
Yeah.
You know, my concern with this case is the way the Supreme Court, kind of in dicta, lumped amendments, lumped the filing of Schedule C and claiming exemption with a amendment to the exemption. One's governed by 522, but the amendment is governed by Bankruptcy Rule
rules.
1009.
Exactly.
Now, it does say matter of course, but at least before Siegel, in the Fourth Circuit, for example, it said
Right.
you're entitled to an exemption unless there's exceptional circumstances. Well, arguably, fraud would be exceptional circumstances.
Right.
By lumping sort of the statute in with the rule,
Yes.
I think it's limited the ability, at least this court certainly said, it's limited the ability to challenge even the amendment, not just the original exemption.
Absolutely. And I mean, it's interesting because law was a situation when we were talking about this earlier, where what they were trying to do equitably directly contradicted a provision in the statute,
Right.
522K,
Right.
which says you cannot surcharge exemptions to pay administrators. So we want to surcharge exemptions to pay. You can't do that. This was not that. This is just amending, and it's like you could say bad faith. Well, I want to also talk, before we move on to the next topic, this is a big issue. Aside from like the tough times trustees are going to have chasing crooked debtors with exemptions and stuff, there are lots of situations in bankruptcy practice where the code seems to sort of say one thing, but bankruptcy practice people have kind of learned means others. So, I mean, Katie, what would be some other examples if we have this slavish adherence to Law v. Siegel as you cannot vary one iota from the statute or even the rules? What are some other common situations where this could be a real problem?
It would be a real problem. I mean, I cannot tell you how many times I go before bankruptcy judges and argue 105A. That is my basis. It's an equitable rationale. But I think the problem you have is there's so many things that are not delineated in
Right.
the code. Yes, our code is this thick, but
Yeah.
there are things that are not in there. For example, critical vendor orders,
No?
not in the code. Roll-ups, not in the code. So what do you do when you need a critical vendor order, when you can't cite to a specific provision in the code that allows that? And I think that's a potential problem that as a result of this decision. So I'm not sure what you do with those.
It'll be interesting. I mean, Judge, you must see this all the time.
Yeah, and I agree with what Katie said. Plus, 105A really deals with an abusive process, and that's what these bad debtor cases are. People who are, hiding assets, and if you can't, and if you can't, exercise some equitable relief when there's an abusive process, then how are you going to do it? You're going to be more limited to do it outside of an abusive process.
Yeah. And it's interesting. I mean, this goes back. It really shows a real change. I mean, you go back to an old Justice Douglas case, Bank of Moran versus England, which predated was sort of the predecessor to some provisions on 542, which had to do with the bank accounts and stuff. And he basically said, we don't read statutory words with the ease of a computer. He said, the bankruptcy judge is looking at what's going on and said, well, this is unfair. This doesn't work. Mm-hmm. And in a case you're looking at, said, Johnny noticed John was like squirreling stuff away in the safe. He didn't forget about $30,000 in cash in the safe. He's like, oh, you caught me. Okay, I claim it as exempt. Ha, ha, ha.
Besides, if he did forget about it, you'd have a trial, you'd have a hearing, he could testify, you could make a factual finding. I mean, nobody's saying he's not entitled to that. But the question is, so if he's going to get away with this, and you can't even prevent the abuse.
You cannot.
And I was going to say just one more thing before we leave this topic. I think maybe had the Chapter 7 trustee knew that this was going to be the outcome, maybe one of the things he could have challenged was filing a motion to dismiss for bad faith, arguing that when you file those original schedules, you are signing them under oath. And he was under oath, and he failed to disclose his $30,000. I mean, that's what got the New Jersey housewife who ended up in prison for lying under oath in a bankruptcy case.
Exactly right.
As Katie says, the denial of his discharge doesn't put any money into the estate to pay for the trustee's efforts.
It does not. Well, let's continue with depressing thoughts, which is medical bills and the means test. I'm reading the case of Erin Marie Zigonina. You're like, this is a woman you initially think, oh, she's lucky. She's one of the people that actually had insurance, except her underinsured medical bills were $82,000. And then she wanted to file Chapter. She also had a very large student loan debt. Problem she has, she's making a decent income, about $100,000 a year. So good chance, if the means test of 707B applied to her, she was going to get kicked out. Then if she wanted to go Chapter 13, she's going to, as an above median debtor, have to pay the full amount of her disposable income. It's going to be like $159,000. So this is going to be really important. The question in the case is, are medical bills, medical debts, consumer debts or not? And that's why it matters, because obviously debtors are only subject to the means test if they have primarily consumer debts. So Judge Mary Gorman, a fine judge I've known for decades, Central District of Illinois, where I come from, she had to answer this question: are medical debts consumer debt or not? She starts with the definition of consumer debt. What does that definition say?
And by the way, I know Judge Gorman too, and I agree. She's an excellent judge with a great reputation, and certainly there's nothing in this opinion that would change anybody's view of that.
Absolutely, very thoughtful opinion.
So under Section 1018, a consumer debt is a debt that's incurred for the purpose of household, family, personal purpose. And
the standard commercial law definition.
Standard commercial law definition, and so that's the standard that Judge Gorman had applied.
So the debtor says, not. Says, what was their argument? What was their other than I really don't want to get thrown into 13? Well, I'm going to have to pay $159. I mean, you have to make a better argument than I'd like to keep.
The debtor had made three arguments. One was relied on a Florida case called Dickerson, and in the Florida case, as Judge Gorman pointed out, it had nothing to do with this issue. It was a case where the question was whether mortgage debt is a consumer debt, and in the opinion, the judge characterized the claims as whether they're consumer or non-consumer, and listed a $460 medical debt as being non-consumer. Never discussed it, had nothing to do with the case, wouldn't have affected the outcome. Judge Gorman said...
What was the only case there?
So you have to grasp for straws sometimes. You take what's out there, you know?
Exactly right.
You do a search like this.
That's right.
We understand. I mean, she respectfully said, I don't buy it, but she didn't buy it. And then the debtor said, well, I'd like to rely on the tax cases.
What's the point of the tax cases? Why do the tax cases say it's not? I mean, when I pay taxes, it feels personal to me.
It does feel personal, but as Judge Gorman pointed out, the tax cases are, the purpose of paying taxes is not a personal purpose, not a direct benefit for the debtor. The standard she adopted was a direct benefit for the debtor or the debtor's dependents. The purpose of paying the taxes is to generate money for the government. It's the public purpose.
What did the debtor try to analogize? I mean, the debtor's argument was the tax debts aren't consumer debts because what?
Well, because
And that also applies to me.
you
She said they're involuntary.
Oh, they're involuntary. Yes.
Right,
yes,
so
yes,
they're
yeah.
involuntary.
Yeah, yeah.
And she said this was not a medical
right, yeah,
procedure.
yeah.
Which I'm really sorry, but I just can't get behind that at all.
No.
I mean,
Yeah.
what is more personal than getting sick?
I know, it's like, it's hard to, and it's interesting. I mean, it is hard. I agree with you, Katie, in the final analysis. It's hard to disagree with Judge Gorman's conclusion. Personal, family, or household purposes, medical bills for you, that's about as personal as it gets. But the consequence, the upshot, is going to be what, Judge? I mean, how will this play out then in individual bankruptcy cases?
Well, the medical debts will be included as consumer debts, and therefore, if the debtor ends up having primarily consumer debts, the debtor will be subject to the means test, and then potentially subject to a determination of abuse.
And boy, so that case like this just shows how. I said this is a debtor that actually had insurance and still ends up in this pickle. Well, fourth topic, we get back into Ponzi schemes. It's always fun to talk about Ponzi schemes. And they seem to be ubiquitous. Obviously, the big play in Ponzi schemes is some people end up getting lucky, the ones that get their money out, and they get paid, and they're even some fake profits, and they're the net winners, but most people are losers, the net losers. And so the ultimate game is net losers trying to get some money back from the net winners and kind of equalize who gets what. Very important question that's coming up is who has standing to bring the clawback actions against net winners? That is, does the trustee have any standing? And if so, is it the exclusive standing, or can other people, the net losers, sue directly? And particularly, can they do that if the Ponzi scheme was set up where the net losers would directly pay, sort of the pyramid scheme aspect of it, the people ended up being net winners. And that's what came up in the telex-free case there. So Katie, very complicated case, but can you kind of tell us what was going on in telex-free and the nature of the scheme, who was suing whom for what, and how that all played out?
Sure. So, first of all, this case is near and dear to my heart as I do a ton of fraud litigation. And when I started reading the opinion, I had a little bit of heartburn because I thought, oh my God, if this comes out the wrong way, I'm in big trouble. Because I do a lot of liquidating trust work as well, so I'm in the same position as Stephen Darr was in this case. And so, what happened in this case is this was both a Ponzi and a pyramid scheme. So
impressive.
very bad stuff. Yeah, very bad stuff. $1.7 billion were lost
Also
as a result of
impressive,
this.
yes.
And there were 1 million participants in this Ponzi. So it was
Crazy.
a monumental proportions. And what ended up happening here is it was an international phone program. So you would buy this membership into this program, and the way it worked is, I think, as you mentioned, there were
telex-free.
telex-free. That's right. There were new participants, and the new participants paid the previous investors. And then at the end, there was no money to pay anybody, and the whole scheme folded.
Actually, a Ponzi scheme.
Yes. So. You had mentioned the net winners. So the net winners, as we know from the Bernie Madoff scandal, are those that they invested less into the scheme than they got out. And so they had a profit. They actually had money in their bank account at the end of all of this, unlike the net losers, who unfortunately got really screwed. So what happened in this case is the trustee was appointed, and he saw this going on and said, you know what, I got to do clawbacks. I got to sue for fraudulent transfers. And so he ended up filing lawsuits against the net winners to claw back some of that money that they got. But unfortunately, in this case, and this is the part that gave me heartburn, the victims, some of the victims, decided they were going to do their own thing. And they weren't going to wait for the trustee to pursue his fraudulent transfer claims. And they went and filed their own lawsuits for unjust enrichment against the net winners. And so it was basically trustee versus the victims who went.
What was the trustee's response when this group of the net losers filed their own unjust enrichment action? What relief did the trustee ask for?
I mean, he wasn't happy, obviously, and he wanted them dismissed. He said, "Look, this is a violation of the automatic stay. I'm the one withstanding here. These fraudulent transfer assets are assets of my bankruptcy estate. I'm in control. I'm in power. I'm the one who gets to do this, not you."
Okay, so he gets the bankruptcy court to try and declare that these things are stopped. So it goes up to the First Circuit. what are the issues the First Circuit has to decide in
Yeah.
this case?
So there were several, and to be honest, at the end of all of this, the First Circuit ended up awarding fees and costs to the trustee. So we know that these all arguments were all kind of without merit, or at least didn't hold a whole lot of weight with the
But
First
they
Circuit.
had a lot of sort of commonality to them. I mean,
Yeah.
there's sort of, at one level, sort of one basic argument. But what was sort of the series of issues that
Sure.
were made?
So the victims, we'll call them the victims, first argued that the trustee had
And
no
they
standing.
were victims.
Yeah, well, they were victims, but they have to let the trustee control the process, in my opinion.
There's
But
that.
so they argued that the trustee had no standing. That essentially, as you had mentioned in your opening, that this was a little funky the way the scheme worked, but it ended up that the money was being paid not to the company,
Right.
but to other people as part of the scheme. And so they were saying, look, because the money wasn't paid to the company, to the debtor entity, trustee, you have no standing.
Because it's not property of the state
It's
at
not
all.
property of the estate. That's right. And the court disagreed. And thankfully, there was some really good language in the opinion where the court said, look, fraud comes in many forms. It isn't always direct, right? I mean, in all the fraud cases I've dealt with, they never make it easy for the trustees to figure out what happens. They always make
You're
it
not
very
a good
convoluted.
fraudster if you do that.
That's right. That's right. And so the court said, that's not going to work. Try something else.
So one of their big arguments, they made a few arguments. So their core aspect is that, what I'm hearing you say is that sort of is it or is it not property of the estate? Because the trustee's obviously in charge of property of the estate, and that's going to be relevant to whether they're violating the automatic stay, whether the trustee has standing to bring clawback actions under 547, 548, and all that. But one of the arguments you said they made is that since they didn't pay it to the debtor, they just paid it to the net winners directly, just not property of the estate. The other argument you said they made is like, well, since it was fraud, it's all just void ab initio.
Yeah.
Okay, what did the First Circuit think of those arguments?
Well, the court, with regard to the void ab initio, the court said, it may be voidable at best, but it's certainly not void.
Right.
Yes, these were contracts that were embroiled in fraud, and we now know that, but it doesn't make it void.
Right.
So the court dismissed that argument too, and they said too that this was essentially fraud in the inducement, and that can't be grounds for a void contract under these
Right.
circumstances.
Right.
And interestingly enough, they also argued in peri delicto as part of the whole standing and property of the estate argument, and the court said, look, we're not buying any of these.
Right.
Ultimately, what the court said is that these fraudulent transfer proceeds are property of the estate. Therefore, the trustee is the one that can pursue these actions.
And the trustee alone.
The trustee alone. That's very, very important because we
Right.
advise our clients all the time. You want to be in bankruptcy court because in
Right.
bankruptcy court, it's all in one forum. You don't have these other parties that can
Right.
sue you in other state courts or federal courts.
Right.
And so, thank goodness the court held that way because it was very. It's. I think that's the right result.
What was their argument? Like, one of the things they really pushed very hard, the net losers who were trying to get their own unjust enrichment claim, was this idea that money, I mean, let's say you're the fraudster, right? But it's like, I am the net loser, and I just pay Judge Catliota, he's the net winner. I just pay him to the scheme is, hey, Charles, are you stupid enough to just give $10,000 to Judge Catliota? It's like, well, sure, I'm really stupid, of course. And then the trustee, you end up going bankrupt, and the trustee says, well, I want to recover that. To which, I mean, I say, what do you have to, I didn't give you anything. Like, what was the First Circuit's reaction to that argument? It's like, I'm just paying him. I don't want my money back from him.
I love what they said, and I'm going to quote this in every fraud case that I have from now on. They said, it was functionally the same as the payments to the company.
Why?
Because essentially, the whole scheme was set up in order to promulgate this fraud. And so they're essentially saying, look.
By the company.
By the company, right. So
Right.
it's fraud in many forms. And
Right.
this is one of those forms, is that instead of paying the company directly, they went to these other net winners. And so the court didn't buy it.
So the only way, so sort of following that, then the only way I could bypass the trustee and just sue the judge, sorry to make you the bad guy here, but you're sitting right
I'm
there.
Johnny.
Yeah. It happens to my students all the time. Would be what? What would be the one situation where I, as a victim, would be able to pursue the net winner directly and the trustee would be out?
Yeah, so they said, and this was a little confusing to me, and I think it always is when you're dealing with the issue of direct versus derivative, but the court said, in the event that the net winners did something because of their individual actions, and the fraud was promulgated because of their individual
So
actions.
it wasn't your fraudulent scheme. If he actually defrauded me directly, not based on the scheme, but
Right.
like his own additional add-on fraud,
Right.
maybe then.
Yes.
But what you're saying is like the First Circuit, and this is why you're going to always quote this, like the fraud comes in many forms. You got to look at the substance of the scheme. It all emanated and would happen because of the fraudulent scheme the debtor set up. Therefore, it's property of the estate, the potential clawback recoveries, and the trustee alone has the power to deal with that. So that's a really significant holding. And by the way, the Second Circuit had taken the same view in the Madoff litigation. Obviously, everybody's trying to sue everything.
And it can't be an avoidance action in disguise, the court said, which is essentially what the unjust enrichment claims were.
They were trying to do. All right, let's move back to Chicago. Chicago seems obsessed with cars, and Chapter 13. And I will alert our viewers, you probably saw this, but Supreme Court did just grant cert in the do you have to give the car back case out of the Seventh Circuit, which also will not just be applicable to not paying fines, but the common scenario where a secured creditor repossesses a car prior to bankruptcy. Do you have to just give it back without getting adequate protection? But in this case, the N. Ray Steen's case, first thing in the first opinion by the Seventh Circuit, the debtors had adopted a practice of trying to have their cars classified, even after confirmation, as estate property. And why, Judge, is that important? If it's estate property, what would that mean?
Well, that would mean that a lender could not go after the car without receiving relief from the automatic stay if there was a claim against the car. If it was estate property and it gave rise to an expense, then it would be an administrative claim that had to be paid by the estate.
Gotcha. So in the original opinion in Steen's early in 2019, the Seventh Circuit said, no, you can't do that. I mean, it's supposed to revest in the debtor. You can't do an end run around it that way. There was the ancillary related issue, though, of, okay, the fines and parking tickets incurred during the Chapter 13 case, are those or are those not entitled to administrative expense priority? Why does that matter, Judge, if it's an administrative expense or not?
Well, if it's an administrative expense, it has to be paid. It has to be paid by the estate.
What if they don't?
And if they don't pay it, the case could be subject to dismissal. A party could come in and make a demand to pay an administrative claim. The judge would require that the administrative claim be paid. Party could come in and seek relief from the automatic stay to go collect on the administrative claim from assets of the estate.
And so it's going to force, if it is an administrative, it will basically force debtors to pay their parking tickets and fines in Chicago if they want to keep playing Chapter 13.
Exactly right.
Okay. Now, the Bankruptcy and District Court said no, said they were not administrative expenses. Why?
Well, there were a number of reasons why, but the primary battleground was over the Reading case, the Supreme Court case that you mentioned, which was a 1968 case, and it was under the old Act. And the Reading case was a case where...
Great facts.
Good facts, yeah, where the receiver under the Act was in charge of administering and operating the debtor's property, a large industrial complex. Through the receiver's negligence, the property burned down, and it was a massive fire. Not only did it burn the debtor's property down, it harmed the neighbor's property.
Basically burned down an entire city block.
Burned down a lot. In fact,
This is bad.
It was such a bad fire that the court even recognized that you couldn't have insurance for this kind of problem.
No,
Yeah.
no.
So
If you burned down the entire city, that's a, yeah.
So the neighbors came in and filed an administrative claim, and the question was, were they entitled to an administrative claim? And the Supreme Court said yes, and essentially said, tort claims are business cost of doing business, and if you have tort claims, you've got to pay them. Now it was an involuntary claim. I mean, nobody was agreed
Well,
to it.
in the Reading Company case, like the dissenter said, that's not, there's no benefit. They said administrative expenses have to benefit. There's no benefit in having to pay tort claims.
Right.
What was Justice Harlan's response to that it's not a benefit?
Well, the benefit is that you're operating the business.
There you go.
You're operating the business, and the policy behind it was, look, presumably the pre-petition creditors are getting a benefit from operating the business, otherwise you'd liquidate it.
Right.
So since the pre-petition creditors are
Right.
getting this perceived benefit, then the question is, why shouldn't the people who are harmed by the operation get paid ahead of the pre-petition creditors?
Yeah, I mean, if essentially they're the residual owners, and you have to bear all necessary expenses.
Right.
So how did Judge Easterbrook analogize that, I think, very appropriate reasoning of the Supreme Court in the Reading Company case? How do you analogize that to paying a parking ticket on your car in a 13?
Well,
you didn't burn down a city block. What's going on?
So the lower courts, the way they interpreted Reading through a Seventh Circuit opinion, said that you have to have two things. You have to have a transaction with the estate, and it has to be fundamentally fair to pay the involuntary,
Okay.
the involuntary claim. And the district court said, yes, it's a transaction with the estate, but it's not fundamentally fair because a debtor is different than a business. An individual debtor is not a business. When the individual debtor is engaged in driving a car, the individual debtor is not engaged in a business, so that rationale doesn't apply.
Okay.
And Judge Easterbrook would have none of it.
So basically, debtors aren't benefited by getting parking tickets, right?
Judge Easterbrook, first of all, Judge Easterbrook made it clear that he doesn't think that the bankruptcy code or the bankruptcy court should be a haven for scofflaws who aren't paying.
Which is a good phrase. I mean, I wish I'd thought of that.
And so and he said, look, the debtors in these consolidated cases, they're kind of, to use the phrase, hoist with their own petard.
How so?
Back in September,
which is another good phrase.
Another good phrase. Back in September, they were here saying, "Hey, these cars are necessary for us to confirm the plan. They're
We
necessary.
have to have our car.
We have to have our cars, otherwise the plan will fail."
We need this for the production of income, which we will use to fund our plan. We must have our car.
Exactly, that was their argument. And he
Therefore,
said,
what?
Look, they themselves have admitted that the cars are necessary. One of the tests for
Yes.
administrative expenses. And so since it is necessary, the operating costs of the car should be administrative expenses. You can't go into a gas station and say, hey, I'm in bankruptcy. Give me gas, I'll pay you when I'm out.
You file a claim.
File a claim.
Yeah, file a claim.
So
pay the gas.
So the involuntary claim is lumped in with the other expenses and has to be paid.
And so the practical takeaway then, as you said, is going to be what now?
Well, the practical takeaway is that these there's two practical takeaways. The first practical takeaway is back in September. If the cars aren't property of the estate, then it's the city is free to go pursue their claims against it.
Right.
If they remain property of the estate in some cases, or in old plans before then the claims will have to be paid. They're entitled to administrative priority and will have to be paid.
And if they don't, yeah. And it's interesting, right? I mean, if the case had come out the other way, I mean, what would the incentives have been for debtors in 13?
Yeah, I think it would have been bad policy. I mean, the debtors.
Park wherever we want.
We can park wherever we want. We won't have to pay this for 4 years, 3 years, 4 years, 5 years.
Yeah, file a claim.
When
Get
we
in
get,
line.
yes, and
Yeah, that's not good.
that's not what you
We
want.
need our car, but we want to be able to park wherever we want.
Doesn't seem to be the policy you want behind your bankruptcy.
You don't. You don't want a haven for scofflaws.
Yeah.
Speaking of scofflaws, let's talk about the Palladino case for our final topic, which major scofflaw, Katie, in Palladino. But it's a topic we've talked about before on this show, but as I said in the introduction, we want to put this on the table so everyone's aware we do now have our first Court of Appeals squarely on point case with regard to the very hot topic right now of whether it's a constructively and could be potentially actually fraudulent conveyance for an insolvent parent to pay college tuition for an adult child. Okay. Well, first, just so everyone's sufficiently scared, why don't we just start with the end? What did they say? Yes or no? Is or is not a fraudulent transfer?
I mean, unfortunately, the court said it is a constructively fraudulent transfer.
Okay, so let's look at constructive fraud. We'll come back to actual fraud. But for constructive fraud, what are the two fundamental elements trustees got to prove?
Yeah, so there has to be a transfer for less than reasonably equivalent value, and the debtor must be insolvent at the time of the transfer.
Okay, so were Stephen and Lori Palladino insolvent?
Well, and this was kind of unfortunately a moot point because they were convicted of fraud in a massive Ponzi scheme, which seems to be the theme of the day, right? 2 months before the bankruptcy case was filed. So I think it's kind of presumed that they were, yes, insolvent at the time.
Yeah. The insolvency wasn't indeed in this litigation wasn't even contested.
Right.
So in this is not uncommon. In these lawsuits, the only contested issue is reasonably equivalent value. That is, the Stephen and Lori Palladino make tuition payments for their sweet daughter Nicole, 18 at the time, and it's like total is almost $65,000 to Sacred Heart University. Sacred Heart says, look, there is reasonably equivalent value. Why? And did the bankruptcy court buy Sacred Heart's argument?
So the bankruptcy court bought the argument, and this is
What was
they
the
argued.
argument they bought?
Sacred Heart said, listen, there's reasonably equivalent value here because the parents of this 18-year-old child want to have a self-sufficient daughter, somebody that can graduate from college without debt. And that was reasonably equivalent value. And the court said, yep, you're right, that is reasonably equivalent value.
I mean, as we were talking before, I mean, as a parent of adult children, I see this as they won't be sleeping in my basement argument.
Yeah.
Right? Which
Yeah.
is a really powerful argument. I subscribe to this wholeheartedly. And it said the bankruptcy court said yes. And it's clearly true. I mean, this has come up in many contexts in constructive fraud, that it's not necessarily required that you be able to point to a dollar for dollar equivalency. I mean, this has come up in a lot of the corporate group transaction cases. I mean, dating back to the Rubin case in the Second Circuit. So, I mean, that like if there's value, it's also, of course, an issue in the LBO cases. But it's like if there's a value there, and parents like, we won't have a dependent child. We'll have okay. Court of Appeals though says what?
The Court of Appeals completely disagreed and said there's no economic benefit.
How so? And from what perspective they say you have to look at it?
So they said there's no economic benefit for creditors of the debtors. That's what they said. And there's no legal obligation specifically to pay
So
the
if
tuition
it
of
were
your
a
child.
minor child, how might the case be different?
I think it might be different.
Why?
Well, so like for example, in New York, the state that I'm from, the age of majority is 21. So
not know that. That's
there's a lot of children, I'm sure, that are in college at 18 and 19 that their parents are paying their tuition. I think it would have been different because then you have something to point to for reasonably equivalent value. Say, hey, I'm a parent and I have a legal obligation to pay for my children's college because they're not an adult yet.
And most courts have agreed with that, right?
Mm-hmm.
I mean, most of the courts where this come up, if it's a minor child, they say the parent is discharging a legal support obligation
Right.
that they have. But the First Circuit basically takes the view here. Since it's an adult child, they say you only judge value from the creditor's perspective.
Mm-hmm.
There's no equivalent value. Now, before we move on, I just want to put on the table that that's a little too broad, right?
I totally agree with you.
Explain.
I mean, can you imagine if that were the standard? I mean, that's a very, very, very broad standard, and I don't think it necessarily fits with the definition of reasonably equivalent value, which is what's required to prove for constructive
Well, I mean,
fraud.
so for example, let's say that Stephen Palladino took his wife Lori out for a nice $400 or $500 dinner for her birthday in the clawback period while he was insolvent. Is that's not beneficial to the creditors? Is that a recoverable fraudulent transfer?
No,
Why not?
because they got a stake. Hopefully,
They got a stake.
They got some reasonably equivalent value for what they were paying for
So,
that $400,
so one
$500
thing to
dinner.
note is that the First Circuit, I mean, perhaps made the right call on the college thing. And I want to I will ask this. So let's say another current topic. Let's say Lori Laughlin had been insolvent when she paid $500,000 to USC to get her daughters into school, which was pretty embarrassing for them. It's like, we're not that stupid. But anyway, could the trustee get back the $500,000?
I don't see why he couldn't under this ruling.
I agree, yeah. It looks like. Now, why didn't, this is something my students are always puzzled by, why wouldn't Sacred Heart have a defense under, let's first start with 548C. Why wouldn't they have a defense there?
Yeah, I mean, it's a good question, and I think the answer is that, that is the section of the code that allows you to have a lien, right, on what you pay if you give
If you
the
give
debtor
value to whom?
to the debtor.
And is there any value to the debtor?
I mean, again, under this analysis, no.
Who's the value to?
The value is to the college.
So the college is giving value to the kid, and that's the same problem. And the other possible defense we have is 550B.
Yep.
Right? How could Sacred Heart and how some schools set it up to save themselves under 550B. What could you do?
And this is really interesting. You can use structured finance
Explain.
to try to protect those payments. And so it's my understanding that what some of these schools are doing is they are setting up a separate account. So when the tuition payments come from the parent, they go to an account in the name of the student, not an account in the name of the school.
So the money, the transfer, the theory then you're saying is Stephen and Lori transferred money to Nicole.
That's right.
Nicole's account then pays, and so that renders the college a secondary
Subsequent- right,
transferee,
subsequent
and thus,
transferee.
and they definitely are giving value and are in good faith vis-a-vis Nicole. Nicole gets to go to school there, clearly valued. And so, I mean, what this decision ultimately means, I think, is colleges are just going to have to make sure to set up their payments where they won't let daddy just write them a check.
That's
Like-
right. And if they don't do this, what I'm finding in one of the
Yeah.
cases I'm working on right now is what ends up happening is the school ends up having to go after the former student who's now maybe just graduated, maybe
Right.
not,
Right.
probably doesn't have a lot of income,
Yeah.
but they can't go after the parents. The
Yeah.
parents are in bankruptcy and they're
Right.
going to be discharged or whatever happens to them. But the child is who they're going to have to, the student is who
Indeed,
they're
the
going to have to
trustee
go after.
could have gone after Nicole, right? Because she's
Yes.
for whose benefit, but Nicole has no money.
Right.
All right. Well, Judge Catliota and Katie, that's all the time we have today. And thank you for your insights on these important decisions. And for the time being, this will mark the final episode of Eye on Bankruptcy here at ABI. It's been a privilege for me to host the program the last year. We thank our audience for watching. There's an archive of past episodes on the ABI website, abi.org. You can check out. In the meantime, this is Charles Tabb reminding you to elevate your understanding and keep your eye on bankruptcy. Thank you both.
Thank you.
Brought to you by the American Bankruptcy Institute. This is Eye on Bankruptcy.